Hi, my name is Dave Rocheford, and I'm a real estate attorney of the law office of David R. Rocheford, Jr. My office represents mortgage lenders and buyers and sellers of real estate. You have a house under contract. You've found the property that you like. You've made an offer. Your offer has been accepted, and you have it under contract. Now the closing process starts at that point. Basically, what the attorney's office does for the lender is they examine the chain of title to the property. They make sure that the seller has good, clear title to convey on to you. If they don't have good, clear title, the attorney's office will work with the seller's attorney or the seller's agent to make sure that they can deliver clean title and deliver a good deed to the new buyer. In the closing process also consists of having our office, or the closing attorney's office, make sure the property is insured by the new homeowner and it meets the requirements that the lender has requested of the borrower to make sure that they stay qualified and have their commitment for the loan in the closing process. We call for tax information to the local town or state, make sure state, local town taxes are paid or adjusted, utility charges are adjusted and accounted for, and any other charges between the buyers and sellers on the property are accounted for. We also take the real estate broker commissions and any other fees that the parties are responsible for paying, make sure they're all accounted for on the settlement statement. Then the final process is basically making sure that the buyer and the lender provide the funds to our office to make sure that everything is paid at closing. The closing process actually comes to an end essentially at the closing table, where documents are signed by the borrower. The seller signs a few documents. They sign the deed and a couple other disclosures. The buyer signs a lot more documents, a big stack of documents, the note, the mortgage, settlement statement, and such. All those documents are signed for a reason. The most important ones are the promise to pay, which is the note, the security instrument for the repayment, which is the mortgage, and then there are disclosures. Every lender has a little bit different form of disclosures and a different amount of disclosures to get signed. But mostly you hear about folks going to a closing and spending hours sitting and signing documents. Well, most of those are fairy tales for the most part. A good closing can be conducted in a reasonably short period of time, 30 to 45 minutes. There is a lot of signing, repeating your name over and over again, signing different documents. But again, the most important ones that you sign at the beginning are the settlement statement, the note, the mortgage, and the truth in lending disclosure statement. Everything after that are pretty much disclosures and nothing to be too concerned about, but there are things that the lender needs executed and acknowledged. Basically, those are things to protect the lender's interest in the transaction and make sure that the buyer or the borrower has received the disclosures that they're supposed to receive. Once all the documents are signed, my office the lender's attorney makes disbursement and pays all the parties. They pay the real estate commission, they pay the taxes to the state, they pay the seller proceeds to the seller, and they put the documents on record at the Registry of Deeds. That's pretty much the closing process in a nutshell.